Thanks, Ian. Thanks, Brady. Thank you, Federal Society. Thank you to Georgetown. So I'm stunned to see this many people on a Wednesday night. Here to discuss. Can everyone hear me? Here to discuss administrative law. So first, I just want to maybe we can cover like what exactly Chevron is. When I was in law school, I guarantee I had no idea what Chevron v. National Resources Defense Council was. Probably you couldn't find 5 people at like most likely who even knew what it was. So what is it? So it's a case from 1984 and it's a 6-0 opinion. It was authored by Justice Stevens. And it basically said that courts will defer in the case of an ambiguous statutory provision. They'll defer to an agency that has competence in that area, right? So pretty straightforward. I think if you asked Justice Stevens, if you told him that 4 decades later, people would be debating this and viewing this as a kind of watershed case, he'd probably be stunned. I think he viewed it as relatively non-controversial. It was sort of conventional wisdom at the time about, the administrative state. He'd be shocked. So what's the fuss about? Like, why do we care? So I guess to sort of frame the question, I thought, thinking about 2 maybe kind of unrelated stories, and hopefully I can kind of stick to dismount and tie them together. But the first one's built on the old quip that the difference between Washington, D.C. and Hollywood is, Washington, D.C. is Hollywood for nerds, right? So, we're here on, Wednesday night doing admin law, so I plead guilty. But I think there's a couple of insights in that statement. One is that, fundamentally, LA and DC are kind of both kind of industry towns, right? There's a kind of like a patina of sort of media stuff that the outside world sees. But if you ever spend time in either one, like they're working towns. In LA, you'll meet cinematographers and sound technicians, and it's not red carpets. It's just about the production of entertainment. Like in DC, your cousins from wherever, they always act like, oh, did you follow this on CNN or Fox? Like, no, not really. What most lawyers in DC do is regulatory code, right? They either are writing it, they're interpreting it, they're advising their clients how to navigate it, or they're litigating it, something. But it's basic regulatory code. And so if you want to know why Chevron's important, it's basically because it's the plumbing. It's like the infrastructure of the federal government. The federal government now governs through administrative code. It's, like those thick books you can pick up, the CFRs. They govern, every aspect of life that the federal government touches. The amount of money involved is staggering. The importance is staggering, et cetera, et cetera. So this is why Chevron matters. Now, the second point is, why are we debating it? That also probably would have been just as shocking to Justice Stevens. On that one, this one's a little trickier to answer. And I think the quip is, that might give the best insight is maybe where you stand on an issue depends on where you sit, right? And the point I'm making with that is that often, throughout history, people's thoughts about administrative agencies' ability to act was tied very closely to their thoughts about, executive power at that point in time, right? So if you go back to the 30s and 40s, you look at the APA and the New Deal, the idea was, the Roosevelt kind of technocrats wanted to govern, and then before the court changed, we're striking everything down as unconstitutional. And again, it's judiciary against administrative agencies. You flash forward, 30 years in the 70s and 80s, and you've got the DC circuit basically like managing nuclear power plants, right? And then, Dick Cheney and Antonin Scalia are, working in the Ford administration. And for them, what they want is a theory of a unitary executive, a strong executive power. They don't want judges intervening, getting involved in policy disputes. So you notice like the sides have shifted, right? So you fast forward in the 80s, when you get basically, again, I think the more conservative side was pushing a kind of deregulatory agenda. And so they were pushing the deference in service of that. I think in the 90s, and this part's very interesting. I think this is kind of one of the more underappreciated aspects. Christopher Caldwell writes about this, but the idea in the 90s was that government was really inefficient. It needed to be much more like a corporation, or it needed to be really nimble. And all these sort of pro-democratic things like notice and comment, they're really cumbersome, and they sort of prevented efficient government action, right? So the idea was just let agencies kind of act quickly and maybe without a lot of the democratic accountability. And so by the time in the 90s, you had cases like Smiley, which basically said, and this is like the Supreme Court, that ambiguity itself, like silence on a provision, was basically there so that the agency could basically fill in the gaps and interpret it, right? So, I mean, it fathom that for a minute. Basically, it means that anything Congress left open amounted to something like a delegation of authority to an agency just to write code and govern that. So that's where we were in the 90s. By the time we get to the 2000s, basically, if you're a federal agency, you can walk into court. You basically just say the words ambiguous and deference, and you got a winning percentage in the 80s, right? And so at that point, I think, okay, so finally, once we get to the Obama administration, we've got Congress is deadlocked. And now I think a lot of conservatives all of a sudden realize, like, maybe that 1980s stuff, maybe we should revisit that. So what am I getting at with all this? One of the nice things about getting older and wearing reading glasses is, you notice the fine line between something cynical and or the fine line between cynicism and wisdom, right? Cynicism would basically go back to just say, where you sit, where you stand on an issue is where you sit, right? Or as like that great nihilist Joseph Stalin said, all politics comes down to who and whom, right? Who is governing and who is sort of being governed, right? And it's a very cynical approach, but there's a tiny bit of truth to that. What I'd submit, and I'm hoping, I think is the wiser and deeper answer, especially for a Federalist Society event, is that what we're going to talk about tonight is basically about the structure of government itself. And it's about tensions that are just inherent and inescapable within the government, about majoritarian impulses, and then about minority impulses trying to stop government action. And they're always in play. They're in a sense ineradicable, and you wouldn't even want to get rid of them. And so I think the key point I'm hoping is that we leave here with a better understanding, at least of the forces at play, in terms of what government action is, the pros and cons of agencies being able to kind of affect majoritarian rule, and vice versa. So with that, I hope that was a helpful kind of framing the issue. And with that point, I'd like to turn it over to Steve.
So if Chevron was the plumbing, the question is, should we restore Chevron? I think it's sort of dangerous when the plumbing is broken. So the metaphor is helpful to answer the question. So Chevron basically was the principle that when the meaning of a statute is unclear, when you're challenging agency action and the statute pursuant to which the agency is acting doesn't definitively resolve the question, defer to the agency if its reading is reasonable. And the underlying theory of it is that Congress delegated that decision to the agency, sometimes expressly and sometimes implicitly. And as Justice Stevens recognized in Chevron, the question there was, what's a stationary source? It's a term in the Clean Air Act. And the question was whether it refers to each pollution emitting piece of equipment within the plant, or does it mean the entire plant? And NRDC and Chevron and EPA were fighting about it because Justice Gorsuch's mother, as administrator of the EPA, had issued a taken a deregulatory approach, and NRDC wanted something stronger, and Chevron, of course, didn't want something stronger. And this case goes to the Supreme Court after NRDC won in the DC Circuit. It's interesting that it was 6-0, and there's a law review article about why it was 6-0 and how the case almost never even got to the court, and then what would we be talking about ever since? Anyway, you should look it up, it's interesting. So Justice Stevens recognizes that, like, we don't know what the heck a stationary source is, but EPA has a ton of expertise with respect to pollution emitting plants and the whole statute, the whole Clean Air Act. So what they said sounds good to us, we'll go with it. And Chevron deference was born. If you read the decision as a whole, it is clear he doesn't think he was doing anything like big, and cites some other cases where there had been some sort of deference or respect for what the agency did. But then after that, you know, Chevron, as Judge Toth indicated, is a fair weather friend for us litigators, for people outside the government. So if a big corporation was challenging an agency action, they didn't like Chevron. If my office, Public Citizen, was challenging an agency action, we didn't like Chevron. But the agencies, they always like Chevron. So one thing that was consistent is whether you were Clinton's working for Clinton or Bush or Obama or Trump, you liked Chevron. So I think it became controversial, though, over time for a couple of reasons. One is in the 80s, I think, and I got this because I read something that then Judge Starr wrote about Chevron shortly after it came out. People thought there'd be a lot more back and forth about what exactly Chevron Step 2 meant, which is when the statute is ambiguous, or when the court finds that I can't decide, the judge can't decide just looking at the statute and purpose and context, can't decide what it means. So they go to Step 2, which is I'm going to defer the agency if the agency's view is reasonable. And it turned out that, like in 94% of the cases, if you get to Step 2, the court said agency wins, it's reasonable. And maybe that's because agencies act reasonably 94% of the time. I mean, you know, but I think that consequence that Step 2 was sort of a joke. It was sort of like, if you get to Step 2, the case is over, made people who were challenging agency action from whatever side less happy about it. And then I think as Obama came in, he's issuing a lot of regs. Congress is doing a little bit, not a lot. They're issuing a lot of regs because the Bush administration didn't. There was a lot to do. So there's a lot of challenges. There's also just pushback against Obama, who rubbed people the wrong way. And there's sort of a increasing effort to minimize agency authority and agency's ability to issue strong public protections. This all coincides with the Supreme Court that shares that skepticism about a strong federal presence. So in that context, challenges to the doctrine of judicial review deference really took off. And everybody knew when it got to the court last year what the outcome would be. So I'm here to tell you why that outcome is bad. So although when I'm in court, that outcome would probably be good, it is a problem now that the court has claimed for itself the sole right to decide how best to implement a broad range of statutory schemes: clean air, clean water, drug regulation, nuclear regulatory matters, like you name it, the court now gets to decide. No one gave the courts, the judges, increased expertise. We don't have subject matter courts except maybe like in the federal circuit, but now they get to decide. And without giving any special consideration to the views or the understanding of the regulators who have deep subject matter expertise, deep expertise with respect to the particular regulatory schemes that they're working on, and the way those schemes interact with other what other agencies are doing or other regulatory schemes, and also agencies that are accountable through the president, through voters, to the public. So now, for For example, under the Food, Drug, and Cosmetic Act, medical devices are approved if there's reasonable assurance of safety and effectiveness, and the FDA has defined how you go about proving reasonable assurance of safety and effectiveness. The FDA has deep expertise in medicine, chemistry, various technologies, statistics. But if someone challenged those regulations in court, the FDA would get no special deference at all. Under the Endangered Species Act, the question, what makes a wildlife species population distinct from another? How should the court decide that question? And who did Congress intend to decide that question? My time is up. I'm going to leave you with those questions.
So, I took a little look, and Chevron came out in June 25th, 1984. And Loper Bright Relentless came out June 28th of 2024. And the Federal Society, the first thing it does is ask the question, should Chevron be revived? And my answer is too soon. It's too soon. But I do think, but since I've been asked to speak on this, it should not be revived. But I was also told this was a Daniel Webster debate. And I thought, well, what do I know about Daniel Webster? Well, I thought, I only know two quotes. So I can paraphrase. An unbiased judiciary is a small thing, but there are those that love it. And I suppose, I think he's also, I could say Loper Bright and liberty, now and forever, one and inseparable. But after I had exhausted my knowledge, and I couldn't figure out how anything related to this debate at all. So I went to a site that had all his speeches and then people who were against him, and I didn't like anything he had to say. And in fact, I thought he was wrong. I thought he was wrong on this constitutional question of whether the president could fire someone. I think he was doing it for political reasons. And he made this speech called an appeal to the old Whigs about how we're going to stop the president from firing people. And I didn't like that. So but Charles Adams, who's John Quincy Adams' son, later after this is going to be the ambassador to the court of St. James during the Civil War, and Henry Adams' father, I thought he had something to say, and I'll just read it. It was in this things, everyone responding to Daniel Webster. It would seem as if in this country, nothing was destined to acquire stability. The Constitution of the United States has now been in operation nearly half a century, during which period many doubtful points in its construction have been thought to have been settled. Settled too under the most favorable circumstances, inasmuch as the framers of the instrument were still existing to explain its meaning, and even present to participate in the decision. They have now, for the most part, passed away, and transmitted to us, their posterity, the comparatively lighter task of preserving the principles they established, of holding the foundations they fixed. Yet the experience of a few past years shows clearly enough that much of their labor was in vain. Now, he's wrong at the last minute. It was not in vain. And the death of Chevron shows that. And I think that the reason it shows it, and I think one of the reasons that it was put on the chopping block, was because of the vast instability in the law that Chevron created. The American law is not like the law of the Medes and Persians that changeth not. But how it changeth is we have a Congress that passes laws, we have an executive who then administers those laws according to what was written, and we got to have a judiciary, an unbiased judiciary that when you bring a case before it isn't going to side with this side or that side because who they are. But Chevron said, for my case, I had herring fishermen, and all in 1990, the Magnuson-Stevenson Act was amended to make clear that the government could put monitors on your boats. And if any, I don't know, you could put these monitors on the boats to watch how many fish you caught, whether you're following the rules. And my clients were around. Nobody lobbied their congressman against it. And my guys are in Rhode Island. All the New England congressmen are very big on this stuff. And the only people who did anything is in Alaska. The agencies had started to charge, and they didn't like that. So Congress actually said in the Northern Pacific, we're all the most dangerous catch, where they go out there and get the crabs, and it's the richest sea resource in the world, I'm pretty sure. They said, you can do this in the Northern Pacific, but we're gonna cap it at 3% of your take, basically, your monetary take. And they didn't allow it anywhere else. There's 2 exceptions, but I only got a few minutes. Anyway, so the point of this is that Congress did think about the issue. Congress did allow these to be charged, and all the fishermen who saw this law coming along, nobody lobbied against it. Nobody. Now, 20 years later, the law is in existence for 20 years. And then NOAA and Commerce and National Marine Fisheries, they say, you know, we don't like how many monitors the Congress is paying for. So what we're going to say is we can have industry contract, and they went through it. They basically said, well, wait a minute. We can't charge them ourselves because any money we charge has to go back to the Treasury. And there's a number of federal laws Congress has put in so agencies can't self-fund themselves. And they think, Congress isn't appropriating enough money. And we know best how much money should be appropriated for everything because we're an agency and we're experts. And so they go ahead and they say, hey, we can't charge it ourselves. We're going to force them to contract with somebody else. And we're going to make a market of this. And so now, when that regulation comes out and you get notice and comment, hundreds and hundreds of notice and comments. All these fishermen who were perfectly happy to have these people on, and they weren't really happy, but they know it's the government's fish. They know these regulations. Everyone I've ever, they all know the tragedy of the commons, right? They are very sure of it. And they think everyone needs to be watched because, of course, they're not going to cheat, but the other guy might be cheating. So nobody minded the monitors. So, but that they were going to be charged for what these were the government employees. These were is basically if the highway patrolman pulls you over and then says, oh, here's your ticket. And also you're going to pay my salary today. That did not hit them right. And none of that was in the statute. And they, as a matter of democratic accountability, they never got to say no to it. They never got to say, hey, Congressman, I think maybe we should have a cap like Alaska, because the Congress put a cap of 3% here and in this other thing, never more than 3%. But we have no cap, and it's going to be 20% of our revenues, 20% when the administrative agencies. You know why? Because they don't care. The administrative agency doesn't care the way a congressman does when his constituency is getting hit. And so I believe in our case, it was very good for another reason. When you go into court, when the judge, he's an independent, he's an Article 3 judge. He's appointed, he's confirmed, he's supposed to only interpret the law as it's found. And suddenly he's got this deference doctrine. And the deference doctrine says if it's ambiguous, and the worst one, the judge brought it up, silence. Well, Congress can't say everything all the time. There's a lot of things they address and they don't address it. But silence is you could just drive a truck through it. Anything they want to do. Oh, you know, Congress didn't say that we could make the fishermen walk on their hands on deck all day, right? They're very silent about it. They didn't say we couldn't do that. So why can't they just do it? Of course, the judge is going to say, well, they're silent. I'm sorry. Now, maybe they would say that was unreasonable, but that was it. That was your only defense, was unreasonableness. So I think that it's very good that Chevron's gone. I hope it does not come back. And I think that it's good for stability in the law, because now Congress has to change the laws. Each administration doesn't get to tick-tock 180 degrees. That's very important for anyone who's trying to direct their conduct through the law.
So, is there a time for rebuttal or? So,
I'll make 2 comments.
Sure.
I'll just sit down. One, I don't think the overruling of Chevron in any way stops the agencies from going back and forth. In particular, because one thing that the Supreme Court had directed lower courts to consider when deciding whether to apply Chevron was the consistency of an agency's position. So if an agency was switching every 4 years, they weren't going to get deference. There's also, I think, less stability because for those regulations that have a 6-year statute of limitations, which really now, because of another Supreme Court case, is an infinite statute of limitations, the likelihood of getting different decisions from district courts and courts of appeals is only escalated because if the plain language of the statute isn't clear, then each judge now is deciding what they think is the best reading instead of defaulting to the government's reading if that reading is reasonable.
Call it that.
Sure.
I'll get to the next.
So is there a mic for questions or should we? Okay, yeah, so if people want to ask questions, you can raise your hand. I have a couple questions I can sort of, but if you have one, just raise, and start then.
Steve, how is judicial deference concerning a generally applicable law not a violation of a party's due process rights? If a judge is naturally inclined to defer to an agency, how does that not affect the neutral arbitrator of due process?
I guess I don't see any I'm not sure how to answer your question. I don't see it as a due process issue.
If I'm a lowly law student suing the government and the agency says, well, our interpretation of this statute is utterly reasonable, the judge has to agree with us. How does that not affect my due process rights to having a neutral arbitrator?
Courts have developed all sorts of tools for deciding cases. Standards of review, burdens of proof, sometimes court, sometimes judge made, sometimes Congress made. And Chevron deference or deference to agencies' reasonable interpretations of statutes is just another one of those tools. I don't think it's any more or less a due process issue than the other sort of principles of statutory interpretation that courts apply all the time and that still exist, although some of them are now altered since June. I do think that originally one important reason for deference was the notion that Congress had delegated the decision to the agency, and the chief, in his opinion for the court in Loper Bright, reiterates that there is still deference when the delegation is sufficiently clear. But one of the things that happened with Chevron deference between 1984 and 2004 is that some courts were saying these are Chevron cases when there wasn't really a reason to think Congress had delegated the decision to the agency. So, I mean, we certainly argued that more than once, that the answer is either A or B. Which one did Congress intend? There's no reason to think Congress intended the agency to decide whether it was A or B. Like, that is a decision for the court. But in other situations where it's ambiguous and there's reason to think Congress did want the court to flesh out the details of how the statutory scheme works, I mean, like, I don't really know what the alternative is, and I don't think the court has really given much guidance. In the oral argument, they kept repeating over and over, Paul Clement and I think it was Gorsuch just kept saying over and over, like, it's the court's job to say what the law is. But when the law is, what the law is unclear, then somebody needs to make a decision. And the question is whether it should be the policymakers accountable to people that Congress has delegated authority to, or whether it should be a judge.
And if I may, she's touched on a very important point. I believe that the district courts use Chevron as a docket clearing mechanism. The Supreme Court kept saying, don't use it this much. You go through and you use all the canons, you do all these things. Well, that's very nice way up there. They take what now, 60 cases a year maybe? And the district courts have how many on their dockets? And they have their chief judge telling them all the time, oh, you've got 275 cases, you got to clear these out. Well, I found ambiguity. Government wins. And you saw this all the time. So I do think that was one of the things driving this. But I will say that the other thing none of us have pointed out, Loper Bright is only decided, we wanted it as a constitutional matter for the reasons you said. And the chief said, no, it's APA. We never mentioned the APA in the Chevron decision. So it's statutory. It's because the APA says that the judges will, decide questions of law in the APA. Now, that's very nice, and I'm happy about it, but I'm not as happy about it as if it was a due process or constitutional issue.
So, question for John, are you worried at all that the pendulum would shift entirely back to where we were in the 70s and 80s, that you'd have judges really intervening in, there's a micromanaging kind of agency action?
Well, here's what I think is going to happen. And, I think that if they try that, eventually the Supreme Court's going to have to say, you're right or you're right. I mean, that doesn't bother me too much because, I'm a critic of the tiny docket, right? So I think that if they have to make a few decisions, if they're circuit splits, I don't think that's the end of the world. Because what circuit splits come out all the time. All us private practitioners who don't, get government deference. Well, we have circuit splits. All our criminal guys have circuit splits that they have to wait until something gets up there. I mean, it happens. I don't think it's the worst thing in the world. And I do think that the Brand X, we haven't discussed Brand X. At the oral argument, the Brand X question, which is an agency decides this regulation is here. The judge says that's a reasonable interpretation of regulations. And then they come back 4 years later and say, oh, we have a new interpretation of the regulation and it's also reasonable. And Brand X said, okay, even though that has been blessed by a court, now this other thing has to be blessed by a court. And I will tell you that what Prelagar herself wouldn't defend it. She was like, oh, I'm not going to do it. And so I think that a lot of this on the question of whether there's going to be judge-made policy, which they all said there wasn't going to be, and then whether or not the law is discernible for regular people and stays the same is the tension here. And I there's that.
It strikes me that even beyond the sort of the questions of statutory interpretation, I mean, just agency, action, adjudication, all of them in front of the Supreme Court. I mean, I think the stability point is something, especially the chief has really been harping on. I think that resonated. I mean, it's in some ways, I mean, I wanted to bring to the highlight the kind of structural federalism, because it strikes me that a lot of what's at stake here is very similar to the kind of fundamental kind of Hamiltonian versus Jeffersonian argument. Hamilton, if you read Federalists like 68, 70, so, it's really about theory of the unitary executive. You need action, you need to be stable, because he didn't want to kind of jump.
He loves Chevron,
yeah.
No question.
Oh, totally, Chevron. Like 90s Chevron. Whereas Jefferson wanted to wipe the books.
So maybe it is constitution.
Jefferson wanted democracy. He wanted that person's elected, they get to make all the laws. That everything is.
When I went to Hamilton College, but I'll tell you.
Yeah, and it's there's a reason these questions are they're perennial sort of tensions in American government.
I think on the circuit split thing, remember that there's a whole slew of cases where there will not be circuit splits because there's a 60-day statute of limitations. All the cases go to one circuit court. So, for instance, if you have a Clean Air Act case, it's going to only be in the DC circuit by statute. If you're challenging certain SEC orders or certain FTC rules, some of those only go to one court of appeals.
True.
So they're not going to necessarily get to the Supreme Court. I think that the chief is also being a little not purposely misleading. He would never do that. But what he says is misleading to the reader when he says this doesn't overturn any cases. The disposition of Chevron, which is that Chevron wins, the EPA wins, is still law. That's true because the disposition of the case, the holding in the case is distinct from the mode of statutory interpretation or the way the court gets there. But so few cases actually get decided by the Supreme Court. So few regulations ever made it to the Supreme Court. So those cases, if the statute of limitations hasn't passed, which it now hasn't for any regulation really ever issued that would go to the district courts, in those cases, you really could have a 20-year-old reg overturned now because it got Chevron deference when it was challenged, in 2000, but now it's going to be challenged again and doesn't get Chevron deference. It is unstable. And then the last thing I'll say, you mentioned that the court had, I think you were saying the court told lower courts from time to time to like cut it out with this like 94% of the agency wins anytime anyone uses the word Chevron. And for instance, when it issued its decision in Meade, which was maybe 2001, something. I remember a lawyer saying to me, this is huge, like this is going to totally change ad law. It was the case that said, don't apply Chevron if they, or consider whether the agency acted with proper formality and consistency and like all these indicators that it what it did is deserving of deference. I don't think it made any difference. I mean, we added the cites to the briefs, but it made any difference. But I think the court was trying, the Supreme Court even then was saying, like, some of you are using it too much, cut it back. And I think litigators, both pro and con on regulations, would have all been happier if maybe the lower courts had listened and cut it back. You were saying?
Yeah, actually, I had a question kind of about that. I'm curious what you think the actual practical impact of this will be, in the sense that, you mentioned that the lower courts, for example, just have these huge dockets. And part of me is thinking that, like, if I'm a lower court judge and I was inclined to defer to the agency either ideologically or just for efficiency's sake, do you really need Chevron in order to defer? I mean, you have Skidmore deference, right? I mean, you could just say, like,
Get more respect, of course, that you tell me.
it's like this is an executive branch entitled to great weight. Maybe your opinion has to be slightly longer. And conversely, if you're opposed to hostile to agency action, like there are enough ways around Chevron with Meade and major questions. So I mean, that's a very cynical and not wise take, but like I'm just curious, like what do you think the actual practical impact is?
So this goes to whose ox getting gored and how people change. I was 30 years old before I lived under a non-democratic house. Okay. And there was a long period of just democratic control of that. Then from basically 1932 to 1968, they were all democratic presidents except one who had to win World War II to get elected. So I think that tells you about who exactly is how this thing is working out. And so then from 68 on, it was all Republican presidents and all Democratic House. And then they decided, we need Chevron. You know why? Because we're never going to control the House of Representatives ever again in our lifetimes. So I do think that kind of practical thing came in. But I do think judges do try to do their jobs. I mean, every now and then, I'm not one of these litigators who like, that judge is in my ideological thing. That's why I lost. I don't really believe that's fully true, except on certain. Yeah, sure. Sometimes, but not for the bulk of the judiciary. I don't believe. I think they're going to try and do what they're doing right now. What we're doing is, it's interesting. The D.C. Circuit took Loper Bright back from the Supreme Court and said we're not sending it back to the district court. We're going to decide ourselves what this regulation is under Magnuson-Stevenson. And to Allison's point, there is the Magnuson-Stevenson Act gives enormous discretion to the secretary, and the secretary may do hundreds of things, thousands maybe, and he must do certain other things. But may is huge, and also since all the fish, I always say, maybe you've seen the Robin Hood movie. Robin Hood doesn't get in trouble for fighting the sheriff of Nottingham or anything. He gets in trouble for shooting the king's deer, right? It's all the king's deer. Well, it's all the government's fish. And all these fishermen are going to do whatever it needs to get access to the fish. And people who control access to fish can get you to do a lot of things. And so I think in my area, it's not as big a deal, except they won't be able to make you pay for things. But I do think that there's this issue of how much discretion each statute gives each head of agency is going to come up for that reason. And I don't think that it's going to be so much Chevron. The next frontier is going to be, the non-delegation, I think.
I'll just add that there are some courts that haven't been applying Chevron for quite a while. The Supreme Court is one. The Fifth Circuit, which now has the bulk of the regulatory cases, is another. Never having seen an agency action that it thought was reasonable. And by contrast, the DC Circuit really leaned heavily on Chevron, both appropriately and too much. I think it'll have no effect on the Fifth Circuit. And in the DC circuit and the district courts of DC, I think it will have some effect. But the judges in DC, I think, are more conservative, not on like a political scheme, but just like how they approach their jobs. They don't really want to go out on a limb. And so I think that they're going to be inclined to often say that the agency's reading is the best reading, which was a step that they didn't have to go to before. As for Skidmore, I agree with some of the justices that I never agree with, who have said, like, what is Skidmore? Like, it's nothing. I agree with you to the extent that you have that you're persuasive. I mean, isn't that true of everybody? But yeah.
I would say that I agree, and this came up, Judge Keflich in the 6th said he's never used Chevron, right? And Justice Judge Silberman, he always used Chevron, and they were kind of ideological compatible, but what your attitude to Chevron mattered a lot. I think about how old you were with anything or anything. But I also think I agree with that. The DC, and plus I have a pet theory that Judge Srinivasan has just been poking him on this. He was just poking the Supreme Court on all these cases, and the term before he had sent up another Chevron case. He said, oh well, there's never good. He did, and
You think he was just daring him?
I think he was daring him because when you read it, every opinion he does it exactly how he's supposed to do Chevron. I mean, Loper Bright is a beautiful Chevron opinion in the DC circuit. You take a look at it; he did everything he was supposed to do, and he did it because he did everything he was supposed to do the year before. And they'd said, oh, this isn't even a Chevron matter. I forget what it was. They used some other thing, and they just didn't even use the word Chevron or anything. And I think he was. I did, and I have no inside knowledge of that. It's just reading these things.
Do you feel that the incentives of legislators when legislating are the same as the incentives of regulators when passing regulations?
The incentives are the same. Huh. I don't know how to answer that. The legislation happens at one point in time, and then the regulators are working for years and years. I assume they are. Congress. Go on.
Can I follow up on that? So, I mean, part of organizational theory is that sometimes to hold a coalition together, you need a kind of calculated vagueness, right? So the ambiguity is there so that you can actually pass a law, right? And so it's not a bug, it's kind of a feature of large legislation. And then the idea would be, I mean, the agencies don't necessarily have to keep coalitions together or things like that. So there's just a fundamentally different prerogative.
Yeah. When Congress passes the Clean Air Act, though, and which I think actually might have even been during the Nixon administration, and tells the agency to regulate, to clean up the air and consider stationary sources, I think that the goal is the same as what the agency does. So I think the objectives are the same. That doesn't mean that Congress would always do it exactly the same, but Congress doesn't really have the expertise, or it would have issued those details. I think the biggest impact of getting rid of Chevron, there might be some impact on how Congress legislates, and to tell the truth, we're getting that question from members of Congress to my office regularly now, what should we say? But I think the biggest effect, certainly in the near term, is on the agencies that are plainly a little bit cowed by this, unsure about how to do their job. Should they just be meeker? Should they do what they think they can do, or only what they're 100% positive is it like the only interpretation of a statute? I think they're definitely going to be meeker, and that and notice proposed rulemaking that are already incredibly lengthy are going to be even longer to try to prevail in the litigation that is inevitable, because there is now litigation over every significant rule and many insignificant ones.
And it also gives there's one other thing. If you just passed Obamacare, or you passed something, this opinion, I think, gives the first out of the box administrators enormous power, because the it's not really deference, but they say that if it is the first people who, when a law is passed, Robert says, we do think they knew what it was about. If it's the administration that got the law passed and then started administering it, there's still some sort of judicial view that that is probably what was intended. So, and then God help you if you try to change it afterwards. I think the first regulator out of the box has a lot of power under this rubric.
So Chevron's not the only deference. There's also what's now our deference, Kaiser deference, which is basically deference to agencies when interpreting their own regulations. And before both of those cases, because Kaiser was 2019, I would have assumed Kaiser was the one that would get knocked down, right? Because, you know, the idea was you had an agency would, you know, promulgate a regulation, adjudicate the regulation, and then enforce the regulation, and that was problematic. But Justice Roberts actually concurred in Kaiser, and it was really a preview. And I think at the moment, Kaiser was a veterans case, so I knew it well. And that was the moment I realized it was actually the statutes are really province of the judiciary, and the regulations technically are more where the expertise of the agencies involved. So those are still, I mean, that principle of deference is still. I guess one question, Jeff, do you think there are any unintended effects of this? I mean, any?
I'll tell you one. Well, first of all, the Fourth Circuit on Friday came down with a Kaiser opinion that basically said Loper Bright doesn't do anything. I saw it on Westlaw because it said most negative of Loper Bright, but so this just came out. But I think the unintended consequence is the one I'm actually as a litigator worried is that I do think that Chevron sped things up, and I think that these district court judges, they're incredibly overburdened. Their clerks, the amount of time it's going to take them to say what the best interpretation of the statute is, I think is going to take more time. I think that a lot of these things will extend the time you get before you get a decision. That's the first thing that I think is going to happen.
Yeah, it's fair. So
I was going to ask, how would you design a deference standard that accounts for agency expertise? Because that's one of the things that kind of worried me about overturning Chevron. Because you know, judges don't have like 1,000th of the expertise that agencies sometimes have. How would you design a standard that accounts for that? If you agree with the premise that there should be a factor for that in a kind of Skidmore or any kind of analysis.
So I always use the Nuclear Regulatory Commission. I always say, you know, all these district judges, they didn't take science or anything. They all took history and economics and government. You know, they're not like. And so they're not going to sit around and go, you know, I think the right amount of radiation you should receive is, you know, X. They're not going to do that. What's going to happen is that if you have one of the other things that Chevron did is it said, oh, you guys have all this expertise. Well, nobody has expertise on who pays. You know who has expertise on that? Congress does, right? So in my case, they said, oh, it's expertise because we know exactly how many monitors we need. And that's not expertise. That's just wanting more money for your outfit. So Chevron drove them to say everything was expertise, but I do believe, and I don't think it's a deference, but they're going to put evidence down, and there's going to be some scientist, and he's going to say, oh, look at this. And so it's not so much, it's almost like a Daubert standard, okay? So in Daubert, you have to have, you know, you can't have world's authority on everything saying, yeah, this is great. You have to say how the science works and why the science is reliable. I think the agencies will have to do that. And I think for the FDA and these others, they will have a lot of evidence on their side, but they're not going to be able to say, I'm the FDA, so I really know the phases of the moon and how they affect you. You know, it's just not going to be this kind of thing going on.
So the agencies get the agency's factual findings do get substantial weight and should not be affected by Loper Bright. And I think the chief recognizes that. He refers in the majority opinion to the State Farm case, pointing out that some cases where you're challenging agency action, it's not because you're saying that their reading of the statute is contrary to law, but you're saying that their choice about what to do is arbitrary and capricious. Those cases usually turn on the facts. And when it turns on the facts, the agency's findings, its cost benefit analysis, its scientific determinations, those do get substantial weight. And I think that I don't think the justices have questioned that. Not yet.
Yeah.
Yeah, I would say I think one of the interesting things is you see this in the major questions doctrine, you see this with delegation, you see this with policy. The Supreme Court's trying to parse out what are interpretive questions, what are policy determinations, what are fact findings, because these can kind of bleed together. And I think the ability to kind of figure out what line of case law you want to kind of litigate under is very important, because the arbitrary and capricious is super deferential standard. I mean, right? I mean, that government will win the vast majority of the time under that.
Two questions. For sake of time, I'll just ask them together. So first of all, Mr. Vecchione, you just said that getting rid of Chevron will most likely make the courts taking more time in the district court level. And I know a lot of people are concerned that it will overcrowd the court system, the federal court system. But Ms. Ziv, you also said in the Fifth Circuit, they haven't used that for a long time. So the Fifth Circuit, includes Texas and some other regions there. And I know, because I interned at a court in Florida, that in Florida, actually the Constitution of Florida got rid of Chevron doctrine 3 years ago now. And what we have seen is that we don't see a catastrophe that happened in the administration of either Florida or Texas because of that. And so far as we can tell, those two states are two of the most booming and well-managed states right now in the United States, I would argue. So what is the, what do you think this would be different?
Well, in the amicus briefs, people put in what had happened in states with no Chevron, including California. But one of our big arguments, certainly mine, was, no one says that California isn't able to regulate, and it doesn't have enough environmental protections in California. The lack of Chevron there has not disturbed anything. But my answer was the federal judiciary, because now, this could be my bias actually, because I think they were using Chevron as a crutch. That is when I was asked the question, I think it may take them longer, but I haven't done any studies. I don't have any. I'm just speculating based on what I know about courts and how they work, but I don't actually know. And people said, look at these states that have gotten rid of their Chevrons or never had it. What's happened to them? I don't know that the question of how fast cases has been determined has ever come up.
Well, I don't think Chevron, the Loper Bright end of Chevron alone is going to overburden the courts. But I think that Loper Bright, in combination with the decision decided the next day, Corner Post, which effectively eliminated the statute of limitations for a huge swath of regulatory actions. In combination, those two could lead to a significant amount of new litigation, because if people may be more incentivized to challenge older regulations now because they would have lost given Chevron, but now there is no Chevron. And because these are all cases that could be filed in the district courts, you can file them over and over and over again.
And it doesn't help the fishermen, because the Magnuson-Stevenson Act gives you 30 days and it's a statute of repose and it's not a statute of limitations. So we still got our 30-day shot out of the box with no.
But you got 2 lawsuits in that time.
That's all right. I had a second separate question. Textually, so in the majority opinion by Roberts, he wrote, when the best reading of the statute is that it delegates discretionary authority to an agency. The role of the reviewing court under the APA is, as always, to independently interpret the statute and effectuate the will of Congress subject to constitutional limits. So he says the court is fixing the boundaries of the delegated authority right now, ensuring the agency is engaged in the reasoned decision-making within those boundaries. So can we see this sort of as a loophole that the court majority is leaving the Congress to sort of being able to very clearly delegate that kind of discretionary authority to an agency.
I wouldn't call that a loophole. I would say that the goal of Chevron originally and the goal of Loper Bright, generously read, is to affect congressional intent with respect to who makes decisions about what a statute means. And if Congress has said, the secretary in his discretion shall determine what the standard should be, then yeah, you should defer unless it was arbitrary and capricious, because the best clear reading of the statute is that Congress wanted the agency to decide. So I think that was sort of implicit in the Chevron decision, but maybe there was a little more willing to go with implicit delegations, and the chief wants more explicit delegations, and he gives some examples in those footnotes on page 17.
But I think you've identified the exact passage that we're going to see used to make a loophole. So
It's not a loophole.
I understand that, but in other words, I believe that paragraph is going to be used by litigators to try to recreate Chevron is my concern with it. I don't think that'll happen. I think your description of it is accurate, but I am concerned about it.
Well, actually, it's okay. I agree with Ms. Steve here, right? Because I use loophole, actually not in an active way, because I'm thinking in the shoes of agency or in the shoes of Congress. What if the Congress really want to delegate, broader power to one specific agency over something that they think the agency should have absolute, interpretive power over? So I think that's a mechanism that
Congress
Roberts
can if it
allows.
wants to going forward. Going backwards, it's not gonna rewrite every one of the statutes in the 50 titles of the U.S. Code.
Yeah, sure.
Okay, so I don't have my gavel, but are we out of time or? Let's see, 7:05. I'm just
Closing.
Yeah, good. But I don't really, close other than I want to thank everybody. It's again a great showing to discuss admin law. Nerds of the world unite, so thank you, everyone.
Good, you're waiting for. No, but obviously.
I know, yeah, it's kind of like interesting.
So,